I don't know. Okay. Now, we're done with nature and forms of contract of sale. Now we talk about who has the capacity to buy or who has the capacity to sell. Okay. When we talk about capacity under this code, sorry. When we talk about capacity under this code, we're talking about legal capacity. Okay. When we talk about legal capacity and we refer to natural persons, meaning kapag natural persons, guys, di ba under the civil code, para malaman nyo, dalawang klase ng persons. We have natural and juridical. When we say natural, tayo ito, mga tao, humans. Okay? When we talk about juridical, these are the corporations, partnership, cooperatives, or other organizations. Okay? A natural person has a legal capacity when he reaches the age of majority, which is 18 and above. Pag 18 ka na, you can, uh, you can, you have a capacity to buy or sell. Just like a person, a juridical person, which are the corporation, the partnership, or the cooperative, or other forms of organizations, if you have a valid and legal existence under the law. Okay, if you are existing in compliance with the law, okay, then you have the capacity to buy or sell. Okay, so yun yung capacity to buy or sell in the general sense. Article 1489 provides all persons who are authorized in this code to obligate themselves may enter into a contract of sale all persons who are authorized in this code to obligate themselves may enter into a contract of sale, saving the modifications contained in the following articles. Okay, when all persons who are authorized in this code, the law talks about this code, meaning it refers to the civil code. Okay, it refers to the civil code of the Philippines. The civil code of the Philippines has more than 2,000 articles. Okay, so lahat ng persons na authorized under this code, okay, hanapin nyo under 2,000 articles, okay, may obligate themselves and can enter into a contract of sale. One of these is yung diniscuss natin kanina. Majority of age and itong sa juridical persons. They can enter into a contract of sale. Okay. We go to the second paragraph. Where necessaries are those sold and delivered to a minor or other person without capacity to act, he must pay a reasonable price. Necessaries are the things or the goods that are essential for our everyday existence or to our schooling, like clothes, food, like expenses in school, okay, medical expenses, all those that are essential to a person. These are called necessaries. Mga medicines pa pala. Okay? Necessaries ang tawag dyan. Kapag binintahan mo ang minor, di ba ang sabi natin kanina, ang age of majority is 18 and above. Meaning, 17 and below are called minor. Okay, bata sila. Meaning, ito sila minor. Other person without capacity to act may refer to an insane person, baliw, or deaf and mute, meaning PP at bingi. Okay? They must pay a reasonable price. Meaning, this second paragraph connotes that a sale to a minor or to an insane person of a necessary is a valid sale. Okay? Kasi ang binenta mo is necessary. Kaya nung bata kayo, pag bumibili kayo ng damit, ng sapatos, ng medyas, binigyan kayo ng allowance na bumili, okay, ng candy, ng pagkain, those are valid sales kahit minor kayo. Okay? Pero generally speaking, this one kasi is an exception. Generally speaking, a sale to a minor or to an insane person or to a deaf and mute may either be voidable or unenforceable. Pero generally, voidable yan. Okay? Voidable. Hindi void, voidable. Anong meaning ng voidable? A voidable contract is a valid contract until annulled. Okay? It is valid until annulled. So, general rule, guys, minor, insane, deaf and mute, ang sale sa kanila is voidable contract, meaning it is valid until annulled. Whereas, if a sale to a minor, an insane, or a deaf and mute is a necessary or yung essential to their existence or to their needs, okay, that is a valid sale. Okay? Kasi itong voidable, pwede yang i-annul ng guardian or ng person with their authority or capacity. Okay? So here's the general rule. As I have discussed earlier, all persons, whether natural, di ba alam natin yan, juridical, alam na rin natin yan. We discussed that earlier. Who can bind themselves have legal capacity to enter into a contract of sale, except persons who are incapacitated. So who are persons who are incapacitated? That we will discuss. Okay? But first, let us know that there are two kinds of incapacities. First, we have the absolute incapacity. The second one, we have the relative incapacity. When we talk about absolute incapacity, okay, these are the persons that cannot enter into a contract of sale. They cannot enter into any contract of sale. Kahit ano, hindi nila pwedeng enter to. Otherwise, yung contract na may enter nila is either voidable or unenforceable as I have related kanina. And this absolute incapacity may be the minor, the demented, or the insane, the deaf and mute. Okay? Except if the sale is a necessary or necessaries. Okay, wherein the sale is valid. Okay? The second one is relative incapacity. We say that there is relative incapacity when the person cannot buy a certain property. Let's differentiate. Absolute incapacity, hindi ka talaga makapag-enter into any contract. Kapag relative incapacity, pwede kang mag-enter into any sale, pero hindi mo pwedeng bilhin yung certain properties. Let's say, for example, pwede mong bilhin lahat ng to except ito. Pwede mong bilhin lahat ng ito except ito. Okay? Relative incapacity. Meaning, you have the capacity, but not with this certain property. Not with that certain property. Okay? Yun ang relative incapacity. And this is discussed by Article 1490 and 1491. Okay? So, we proceed to number 1, husband and wife. Meaning, husband and wife under relative incapacity, meaning The husband cannot sell to the wife, and the wife cannot sell to the husband. Okay, that is relative incapacity. Why? Because it is absurd. Di ba? Asawa mo, bibentahan mo, asawa mo na. Di ba? Sabi nga nila, lahat ng ari-arian nyo is sa inyong dalawa. Ba't mo pa ibebenta sa kanya? Kung in the first place, sa inyo namang dalawa. Ano itong kalokohan? Naglolokohan kayo, di ba? Kasi yung property nyo is pag-aari nyong dalawa. Ba't mo pa ibebenta sa kanya? Kasi yung dalawa naman na yan. Di ba? Kalokohan. Husband and wife. Kaya siya bawal. Okay? But the main purpose of this law is to avoid the creditors from being prejudiced. Okay? Ay, mali yung spelling ko. Prejudice. Not to prejudice the creditors or not to defraud the creditors. Why? Let's say, for example, si husband merong utang. Let's say, for example, 800,000 pesos. Okay? Wala na siyang cash. Hindi niya na mabayaran. Pero meron siyang isang lupa. Yung tinitirahan nila ni wife. Okay? Nasa kanya pa nakapangalan yung lupa na yun. Sa kanya pa nakapangalan. Ngayon, naisip niya na baka i-attach yan nung kalaban ko. Baka makuha yan lupa sa akin dahil may utang ako. Ang ginawa ni husband, binenta niya kay wife. Okay? Dun, at that instance, the creditors are prejudiced. The creditors are defrauded. Why? Because the husband is now trying to evade the creditors. In that way, wala nang masingil ang creditors kay husband. Kaya, bawal magbenta si husband kay wife. Okay? Just to share, before kayo ikasal, meron tayong tinatawag na pinag-uusapan yung dalawa na mag-asawa or na magpapakasal na marriage settlement. Ito yung tinatawag nating yung tinatawag ng iba na prenuptial agreement. Diba? Prenup. Bago kayo ikasal, pag-usapan nyo kung ano yung property regime na magko-cover sa marriage nyo. Attorney, ano itong property regime? Okay? Ang property regime, merong tatlong klase yan. Una, absolute, take note, absolute community of property. Absolute community of property. Meaning, lahat ng pag-aari mo na gusto mong dalhin sa marriage at lahat ng ma-acquire nyo during the marriage is sa inyong dalawa. Yun ang absolute community of property. Ang conjugal partnership of gains naman, lahat ng income na ma-earn nyong dalawa at ma-acquire nyo na property is sa inyo. Take note, magkaiba yan ha. Ang absolute community property, lahat ng dadalhin mo sa marriage at ma-acquire nyo during the marriage is your property. Belongs to both of you. Okay? Kapag conjugal partnership of gains, naman, lahat ng income or ma-acquire nyo during the marriage is sa inyong dalawa. Okay? So you see the difference. Number 3 naman, separation of property. Ito ang pinakamaganda sa mga mayaman. Why? Separation of property. Kasi yung kay husband lang. Yung kay wife lang. Separate. Ayan ang separation of property. Ngayon, kung ang marriage regime mo ay absolute community of property at conjugal partnership of gains, hindi pwedeng magbenta si husband kay wife or si wife kay husband. Okay? Pero kung ang property regime mo ay separation of property, pwedeng magbenta si husband kay wife. Why? Because separate ang property nila. They cannot defraud the creditors kasi magkaiwalay yung properties nila. Dito kasi sa 1 and 2, both of them owns the properties. Diba? Napaka absurd naman na ibebenta niya ni husband kay wife yung property na silang dalawa ang may-ari. So husband and wife will sell to wife. Ganon yung lalabas sa deed of sale. Okay, which is hindi it's an evidence, it's a prima facie evidence actually na they are trying to defraud someone, which could be their creditor. They are evading someone. Okay? So take note of those things that I have discussed. The second one is the guardian and the property of persons under his guardianship or the ward. Meaning, si guardian, hindi niya pwedeng bilhin yung property ng ward. For example, merong isang minor sa bata. Okay? Wala siyang legal capacity. Okay? Namatay yung parents niya, dalawa, both are billionaires. Diba? Namatay sila. Siya lang yung only son. So, si minor lang. So, under the law, siya ang magmamana ng lahat ng ari-arian ng parents niya. So, lahat ng properties, lahat ng pera, lahat ng businesses, corporations, or partnerships na kasali yung parents niya, siya lahat ang magmamana. The only problem is, minor pa lang siya. So, he needs a guardian or an administrator of the property. Si guardian yung magmamanage or administrator ng property. Ngayon, dahil siyang naghahawak ng property, nagmamanage, nag-administer, pwede siyang maka-exert ng undue influence kay ward. Or pwede niyang maabuso ang kanyang position bilang guardian. Diba? Kung ganyan kayaman, di siyempre, bilhin mo na yung mga properties niya at a lower price. Sino namang pipigil sa'yo? Ikaw yung guardian. Diba? Ikaw ang nagmamanage, ikaw ang nag-administer. Wala namang kay-question sa'yo. Diba? Kaya siya pinagbawal. Okay? The third one is agent and the property of the principal. Take note, diba, under a contract of agency, the agent acts in behalf of the principal. Okay? Therefore, he cannot buy the property kasi it's absurd. Why will the agent buy and he's acting for the principal? Therefore, the principal will sell to the principal. That is absurd. Diba? Kaya bawal. Okay? Unless or except the agent is acting in his personal capacity and he has the consent of the principal. Okay? Kapag meron yan, then the agent can buy the property. Okay? Executors and administrators and property of the estate under administration. So, para maintindihan nyo, executors and administrators, alam niyo yung last will and testament. Yan. Bago mamatay ang isang tao, pwede siyang gumawa ng last will and testament. Ibig sabihin, kung kanina mapupunta yung lupa niya, yung sasakyan niya, yung properties niya, ilalagay niya lahat yan sa last will and testament. Okay? Ngayon, kapag may last will and testament, ang tawag dyan, testate succession. Okay? Testate. Under the last will and testament, pinapangalanan na nung namatay kung sino yung executor. Anong ginagawa ng executor, attorney? Siya yung nag-execute ng last will and testament. So siya ang mag-gather sa mga naiwang heirs kunwari may mga naiwan siyang kapatid, patatawagin niya yan lahat at babasahin sa harap nila yung last will and testament. Okay, sa iyo mapupunta ang ganito, ganyan, ganito, ganyan. Okay, tawag dyan executor. Ngayon, kung walang nagawang last will and testament, okay, tawag dyan intestate. Intestate. Okay? Ang tawag naman sa nagmamanage ng properties niyan ay tawag dyan is administrator. Okay? Yun yung administrator. Since walang last will and testament, either the court or the heirs themselves will choose who will administer the properties. Okay? Yung estate na tinatawag natin, yan yung lahat ng properties na naiwan nung namatay. Lahat ng lupa, lahat ng bahay, lahat ng kotse, sasakyan, lahat yan kasama sa estate. Okay? Since sila yung executor at administrator, they can exert undue influence din, di ba? Undue influence and abuse of their position. Since sila yung nag-execute ng will, pwede nilang sabihin na bilhin na lang namin yung properties. Di ba? Number 5, public officers and the property of the state. Of course, how can the state meaning the government, okay? How can the government or the state act? They act through the public officers and employees. Diba? Kasi itong si state or si government, hindi naman yan tao eh. Nag-act ang government or state through the public officers or employees, yung mga government employees, mga nagtatrabaho sa munisipyo, they represent the state, they represent the government. Mga nagtatrabaho sa DNR, BIR, lahat yan government employees. Okay? Hindi nila pwedeng bilhin yung property ng state. Okay? Hindi nila pwedeng bilhin. Why? Because that would result in a possible taking advantage of their authority or position. Diba? Or could really result into graft and corruption. Okay? Kasi since they are the ones who are handling or managing the properties of the state, then therefore they can manipulate the sale of these properties. Diba? Kaya bawal. The 6th one is justices, judges, prosecuting attorneys, clerks of superior and inferior courts, and other officers and employees connected with administration of justice, the property and rights in litigation. Meaning, let's say for example, si judge nagtatrabaho sa court. Meron siya yung nag-hear ng case. Okay? If a case is filed in his court, okay, involving a property, okay, na siya ang magdidinig, siya ang mag-hear ng case na yun, si judge. Habang ongoing yung hearing nitong kaso na to, hindi pwedeng bilhin ni judge yung property. Okay? Habang ongoing yung hearing. Okay? Why? Because it may affect the decision or his decision. Bakit niya bibilhin? Diba? Ongoing case under his sala. Hindi pwede yun. Okay? Ganun din sa mga prosecuting attorneys or sa fiscals, sa clerk of courts, or kahit sinong empleyado ng korte. Hindi nila pwedeng bilhin yan. Uy, ongoing kaso ng ganito. Maganda yung lupa na yan. Bilhin natin. Oo. Para ganito ang decision. Para mabili natin. Diba? Bawal yan. Okay? This prohibition sa number 6 also applies to attorneys or private attorneys or private counsel. Okay? Meaning, itong property na to, meron siyang abogado. Si abogado, hindi niya rin pwedeng bilhin yung property. Pag ongoing yung case, yung hearing, si abogado, hindi niya pwedeng bilhin yung property. Bawal din. Okay? Tandaan, basta yung property under litigation, hindi pwedeng bilhin ng mga nagtatrabaho sa korte. Okay? Kasama nandyan yung abogado. Bawal yan kasi that may affect the decision of the judge or how the attorney handles the case. Diba? Pwede niyang patalo, panalo. Okay? Because of that situation, kaya bawal. Okay? 1490, I have discussed actually the husband and wife cannot sell property to each other. Pero meron siyang exception. Yung unang exception na discuss ko niya, kapag separation of property yung napag-agrihan sa marriage settlements, di ba? Sabi ko kanina, kapag separation of property, the husband and the wife, ay, yung kay husband lang, yung kay wife lang. Therefore, they can sell their properties to each other. Pwede lang. Kapag absolute community at conjugal partnership of gains, hindi pwedeng magbenta. Okay? Another exception is judicial separation of property. Okay? Ang difference ng separation of property, this is an agreement. Dito naman, this is a judicial declaration, meaning this is a decree of court or order or judgment of court. Okay, merong order ang court or decree ang court. Dito kasi sa una, agreement. So general rule, husband and wife cannot sell to each other except separation of property or judicial separation of property. Okay? Take note, this prohibition, yung bawal magbenta ang husband and wife sa isa't isa or yung wife at husband, applies also to common law relationships. Attorney, anong common law relationship? When we talk about common law relationship, these are persons living together without the benefit of a marriage. Ibig sabihin, nagsasama kayo na hindi kayo kasal. Yan ang common law relationship. Or yung tawag nila, colloquial term, or is live-in, di ba? You are living together without the benefit of marriage. Okay? Live-in. Okay? Bawal din magbenta si ka-live-in kay other ka-live-in. Okay? Bawal din yan. Same is the reason sa husband and wife. Diba? Kung si ka-live-in merong property at meron siyang utang na wala na siyang pera, ibenta ko na lang kay ka-live-in ko. Magka-live-in naman kami. Parang sa akin pa rin yung property. Okay? At least, hindi na ako makukolektahan ng creditor ko. Wala siyang makukuha sa akin. Safe ako. Ganun yung gustong hindi mangyari ng batas. Kaya, bawal kahit magka-live-in kayo. Okay? And also, this also applies to donations. The husband cannot donate to the wife. The wife cannot donate to the husband and also to the ka-live-in. Okay? Why? Ganun din, same. Parang sale lang din, pero ito donate. Donate niya yung property niya para walang makuha si creditor. Okay? Ganun yung scenario. Kaya bawal ang donation din, pati sale. Okay? 1492, in the two preceding articles, are applicable to sales in legal redemption, compromises, and renunciation. Sabi dito, the prohibitions in the two preceding articles. 1492 ito, so two preceding articles is 1491 and 1490. Therefore, 1491 and 1490, itong mga prohibitions na to, okay, nag-a-apply din sa legal redemption, compromises, and renunciations. Okay, mag-example tayo ng isa. Okay? Let's say, for example, yung sa attorney na lang. Okay? Let's say, for example, ito ang lupa ni client. Ito ang lupa ni attorney. Okay? This property is undergoing a case which is filed in court wherein attorney represents the client. So, abogado ni client si attorney. Okay? Ngayon, si client sobrang na-stress na gusto niyang ibenta yung property. Okay? As part of the law, okay? As part of the law, she can sell the property, of course, kahit pa under litigation yan. Okay? Pero bawal bilhin ng attorney. Ngayon, pwede niyang ibenta ito, pwede namang i-redeem ni attorney ito. Why? Because he is an adjacent owner. Anong ibig sabihin ng adjacent owner? Katabi niya yung lupa. Pwede niyang i-redeem yan. Because he will greatly benefit kapag nabili niya yung lupa. Okay? Kaya pwede niyang i-redeem yan as an adjacent owner. Pwede rin bilhin nung katabi niya na pwede rin bilhin ng tao na katabi niya ng lupa. Okay? Pero since sabi dito, nag-a-apply din ito sa legal redemption, therefore, bawal din. Hindi niya din pwedeng i-redeem. Okay? So, hindi pwedeng sale, hindi pwedeng redemption, compromises, and renunciations. Effects of the contract when the thing sold has been lost. Okay? This is very simple. If at the time the contract of sale is perfected, kailan merong perfection? When there is a meeting of the minds, meaning both parties consented to the object or to the manner of payment or to the price of the thing. The thing, which is the object of the contract, has been entirely lost. So nawala talaga. The contract shall be without any effect. Okay? Meaning void. Paano ito example? I own a house. Okay, I own a house. Yan, house. Yung house lang Okay. Yan, house. Ngayon, I entered into a contract. I agreed into a sale with A na ibebenta ko yung bahay ko kay A. Okay? So at that time, the contract is already perfected because we already agreed that A will buy the property at a certain price. Okay? Ngayon, unknowingly, nung araw na yun or habang nag-uusap kami or after namin mag-usap, hindi ko alam na yung bahay ko nasunog pala. Okay? It was burned down to ashes. Okay? So, wala na yung bahay. The thing is entirely lost. Ngayon, nung titignan na namin yung bahay, pupuntahan na namin kasi nakapag-agree na kami. Naggulat kami na panay-abo na lang. Wala lang natira. As in, wiped out. Okay? That means that the contract of sale is without any effect. The contract of sale is void. That's the example. Okay? But, if the thing has been partly lost only, okay? Partly lost. The buyer has a choice. So, kung partly lost, the buyer has a choice whether to, number one, withdraw from the contract. Sabi niya, ayoko na. Ang sabi ko, bahay at lupa. Pero bakit lupa lang? Nasunog yung bahay. Ayoko na. Withdraw ko. Okay? Pwede yun. Second one is to demand the remaining part provided babayaran yung price in proportion to the total sum agreed upon. Okay? Kung house and lot yung binenta, pati yung lupa, house and lot. Okay? Kapag nasunog ito, pero gusto pa rin bilhin ni A itong lupa, he may do so. Okay, pwede. Provided that he pay the price in proportion to the total sum agreed upon. Okay? A thing is lost when it perishes, goes out of commerce, okay, it goes beyond the control of man, disappears, or it becomes unknown, or it cannot be recovered. It is considered as loss. There could be a partial loss, there could be lost in its entirety. 1494, where the parties purport sale of specific goods. Take note, 1493 speaks about thing. Ito tandaan nyo compare nyo. Thing ito, 1493. So 1494, specific goods. Same lang siya kasi. Okay? And the goods without the knowledge of the seller have perished in part, so partly lost, have wholly or in a material part so deteriorated, either partly lost or the whole or part of it is deteriorated in quality. The buyer has two options, either to, number one, as avoided or rescinded. Number two is to pay the agreed price. Okay? Provided that the sale is divisible and proportionate naman yung price na babayaran niya. Diba? Yung sa kabila kanina, 1493 thing, ito is specific goods. Let's say, for example, I have a warehouse where it contains 100 sacks of rice. I agreed with A that I will sell 100 sacks of rice to A. So, okay na. Nung pupuntahan na namin yung warehouse, nagulat ako na 50 na lang na sacks of rice yung available kasi yung 50 is either nabasa or natangay ng baha or something, nasira. Okay? So 50 na lang yung pwede. The buyer can rescind the contract or pay the price as agreed according to its proportion. Yun yung 1494. Okay, so the difference between 1493 and 1494 is yung 93 thing, yung 94 specific goods. Yung 93, kapag partly loss, the remedy is withdrawal and demand the remaining part, which is to pay the appropriate price. Okay? Yung 1494 naman, the buyer may rescind or pay the prices agreed upon. Okay? Now, let's proceed to the last part of our topic, sale of real property in installments. Okay? Before this topic, we've discussed about sale of personal property in installments. Diba? Ito yung tawag nating recto law. Okay? Under this law, diba? We have discussed before that there are three remedies of the seller. Okay? The seller can exact fulfillment of the obligation, rescind the contract of sale, or foreclose the chattel mortgage or the mortgage. Foreclose the mortgage. Okay? Under sa sale of real property naman, kung ito personal property, mga laptop, kotse, motor, yan, personal property yan. Itong real property naman, bahay, lupa, yan, house and lot, yan, lahat real property yan. Ito yung tinatawag nating Macedo. This is also known as the Realty Installment Buyer Act. It is hereby declared a public policy to protect buyers of real estate on installment payments against onerous and oppressive conditions. Before kasi, the sellers of real estate can just dictate on the conditions that are oppressive to the buyers. Okay, that's why the Macedo law is enacted to protect the buyers. So here is one of the rights of a buyer. So in a sale of a real estate or financing of a real estate, kapag si buyer na kapag si buyer nakapagbayad ng at least 2 years of installments, meron siyang rights. Ito yung A and B. So his first right is to pay without additional interest the unpaid installments within the total grace period. So how do we compute the total grace period? Under the law, ang sabi is 1 month grace period is earned for every 1 year of installment. So if naka 2 years na installment ka, therefore you're entitled to 2 months grace period. Okay? So kung at least 2 years, therefore you're entitled to 2 months grace period. Okay? Therefore, si buyer dapat magbayad within 2 months grace period, okay, without additional interest. Okay, without additional interest. Pero ito at least 2 years. So pwedeng 3 years na siya nagbabayad. Kung 3 years na siya nagbabayad, 3 din yung monthly grace period niya. Kung 5 years na siyang nagbabayad, 5 months din yung grace period niya. 5 months na walang additional interest dun sa kanyang babayaran. Provided that this right shall be exercised by the buyer only once in every 5 years of the life of the contract and its extension. So only once in every 5 years. Okay? So kapag na-exercise mo na itong right na ito, hindi mo na siya pwedeng exercise within the next 5 years. So, ma-exercise mo siya after 5 years ulit. Pwede ka na ulit mag-avail nitong right na provided under letter A. Attorney, paano kung despite the monthly grace period, hindi pa rin nakabayad si buyer? Then, the contract is canceled. Yun lang ba yun? No, before that happens, the seller shall refund to the buyer. So, i-refund niya kay buyer yung cash surrender value of the total payments made ni buyer, which is equivalent to 50% of the total payments made. Total payments made na hindi price nung property. So if you made so lahat ng nabayaran niya na installment times 50%. Okay, kasi 50% lang yun. Pero after 5 years niyan, okay, after 5 years, let's say for example for the 6th year, meron siyang plus 5%. For the 7th year, meron siyang plus 5%. Okay? Ibig sabihin, itong 50 pwede pang tumaas. Provided na hindi siya mag-exceed ng 90%. That is stated under the law. Okay? Take note, before ma-cancel itong contract of sale between the buyer and the seller, dapat meron munang number 1, notice of cancellation or demand for rescission. Dapat meron muna yan. And full payment of the cash surrender value. Okay? So take note, kung at least 2 years kang nakapagbayad ng installment, pwede kang one of your rights sa buyer is to pay without interest yung unpaid installment mo. So within 2 months, pwede mo yung bayaran. Okay? But, depends on the monthly grace period that you can earn. Kung let's say, for example, naka 4 years ka, nagbayad ng installment, you have 4 months na grace period. Okay? Na walang patong na interest. Take note that this will be exercised once in every 5 years. Ngayon, kung hindi ka naman nakabayad despite of the 4 months grace period, okay, then the seller may cancel the sale. How can the seller cancel the sale? Okay, he can cancel the sale only after notice of cancellation or demand for rescission and full payment of the cash surrender value to the buyer. How do we compute the cash surrender value to the buyer? The cash surrender value is equal to 50% of the total payments made. Okay? Provided, of course, na kapag after 5 years ng installment, magka-earn siya ng 5% for every year. So kung 6 year, 5%, 7 year, 5% ulit, up to 90% lang. Hindi na siya pwedeng mag-exceed ng 90%. Okay? Now, in the computation of installments, kasama ang down payments, deposits, or options. Okay? Kasama yan sa pag-compute ng installment. So, kung malaki yung down payment mo, so, i-compute yan as your installment. So, pwedeng lumampas sa 2 years, sa 3 years ang installment mo pag binilang pati yung down payment. Section 4. Yung kanina, sabi natin sa Section 3, at least 2 years. Dito naman, less than 2 years ang nabayaran mo. So, pwedeng 1 year and 10 months, 1 year and 7 months, okay? Basta less than 2 years. Sabi ng batas, meron kang grace period na not less than 60 days. So, ang grace period mo ay hindi bababa ng 60 days. Pwedeng 60, pwedeng 70, 65, basta hindi siya bababa ng 60 days. Okay? Pero kapag hindi ka nakabayad dito sa despite the grace period, makakancel ang contract mo. Paano? Okay? By furnishing you a notice of cancellation or demand for rescission. Pag nabigay na ni seller yun, he can cancel the contract of sale. Kaya, i-compare mo ang 4 sa 3. Okay? Sa 3, kapag hindi ka nakabayad, i-cancel yung sale mo. Parehas. Paano i-cancel? Number 1, magbigay ng notice of cancellation dito or demand for rescission. Parehas. Ang difference, number 2 sa section 3. Meaning, babayaran mo yung cash surrender value to the buyer. Okay, which is 50% of the total payments made. Kung hindi mo ito mabayaran, hindi mo makancel yung sale. Pero sa 4, notice of cancellation at demand for rescission lang ang kailangan. Wala nang payment na kailangan. Okay? Therefore, notice of cancellation lang, pwede na i-cancel yung sale. The buyer shall have the right to sell. Of course, the buyer can sell his rights, his assigns, or reinstate the contract by updating the account. Diba? Bago makancel, nagkaroon siya ng pera kaagad, pwede niyang i-reinstate yung contract. Basta hindi pa nakakancel yung contract. Then, the buyer shall have the right, of course, pwede siyang mag-pay in advance in an installment kung may pera siya, pwede. Or pwede niyang, kung sobrang nanalo siya sa loto, pwede niyang bayaran yung full unpaid balance. Kung may natitira pa, pwede niyang bayaran. Pwede. This is without interest. Okay? Then, the last one, any stipulation contrary to section 3456 of what we discussed earlier shall be null and void. This one is provided to secure the buyer or to protect the buyer from the practices of the sellers of real estate. Okay, na masyado nang inaabuso. So that ends my topic. We will not have a quiz yet. We will not have a quiz yet. Ang ano ulit natin is next meeting, discussion ulit. But, kaya ang sabi ko kanina, may mga magre-recite next meeting. Okay? So, that's all for tonight, guys. Thank you for listening. Thank you for attending the class. Good night, everyone.